Swayam Prabha. Digital India. Educated India.
Dear viewers, I welcome you all on the lecture number 5 on the topic of interpretation of statutes. My name is Dr. Ajay Sonamne, Assistant Professor, Faculty of Law, University of Delhi. So dear viewers, today we will be discussing on the topic of principle of external aids to the interpretation. So before we begin with the lecture, let us try to understand that what we are going to cover in this particular topic. So in this topic, we are going to discuss about the brief introduction about the aids to the interpretation, then how this external aids to the interpretation is helpful while interpreting the statute. Then along with that, we will try to understand that several category of aids to the interpretation that comes under the external aids of the interpretation. So here there is a first one that we will discuss, parliamentary history, then historical facts and surrounding circumstances, then social, political, economic development, scientific invention. Then we will discuss the reference to the other statute, usages and practices which is come under the external aids to the interpretation. Then we will discuss the dictionary and textbooks and use of foreign decision and the documents. So these are some of the categories of external aids to the interpretation. It may add, or there are few more can be added in the future as per the need and time. So to begin with the first, that is the introduction of the aids to the interpretation and specifically the external aids to the interpretation. So here, as we aware by now that it is the primary role of judiciary to interpret the law and interpret the statutes in a manner in which it can give the correct meaning to the text of the law as well as the spirit of the law can be maintained. So while doing that, there are sometimes situation arises when the judiciary or the lawyers for that matter may not able to apply or may not able to interpret certain words which are ambiguous or which are vague. So in this process, or to make this process easy, there are certain aids to the interpretation that has been introduced or that has been picked up by the several judicial pronouncements or judicial deliberations. So here the aids to the interpretation of statutes basically assist or help to the lawyers or the judges to interpret the law, and this aid is nothing but the assistance or help. So here, if there is no clarity from the statutes, right, so then requires help from the various other sources to understand the intention of the legislature. So if the words of the statutes are not clear, if the words of the statutes are not giving the correct information or correct meaning to the word, then in that case what can be done? There are other sources will be find out, and with the help of other sources the meaning of that act, that statute, that provision of that statutes can be taken out. So therefore there are primarily two category of aids, that is, one is the internal aids to the interpretation and second one is the external aids to the interpretation. So in this particular lecture we will focus on the external aids to the interpretation. So external aids, as the title, as you can see here, the external aids to the interpretation is something that is externally available or externally present, and it is the job of judge or it is the job of lawyer while arguing the case that to take the help of these external sources which are outside the particular act. Okay, so in the external aids to the interpretation, what is basically focused upon or what has basically emphasized upon, that there are certain sources, there are certain types of aids which are available outside the legislation. So if the words of legislation are not clear, if the words of the particular provisions are not clear, then judge will try to understand the meaning of that text or meaning of that provision with the help of external sources. Okay. So under the external sources, that means they are not the part of act, they are not part of the statutes, they are available in the external, you can say in the external sources, and therefore court can rely and interpret the provision and take the assistance from it. So generally, as we know that when we interpret the law, then we try to understand the text of that particular legislation, we try to interpret that in a similar manner. But if the words are not clear, then one may have to take the assistance which are available at the outside that particular legislation. So here the external aids to the interpretation that we discuss, then there are certain categories of external aids. So first here the parliamentary history, which is inclusive of the three practices, that is, one is the English practice, second one is the American practice, third one is the Indian practice. So we will try to understand that how the parliamentary history is one of the important external aids to the interpretation. Then we have these historical facts and surrounding circumstances. Then there is a social, political, economic developments and scientific inventions. Then reference to the other statutes. Then usages and practices, which is based on the Latin maxim, contemporanea expositio. Then dictionary and textbook and use of foreign decisions and the documents. So these are certain types wherein you may not get this particular information in the act, but for that purpose you have to search this information which is associated with that act in some external sources, or with some external sources like parliamentary history, or maybe some historical aspects or social, political, economical developments. So this, because ultimately, like, if you just imagine that whenever any law is framed, law is not framed with just with the words or alphabets, with taking some alphabets from English but or any other language, but law is made with the help of how or what things are happening in the society, what are the needs of from that society, and what are the requirement of the society. Based on that, law will be framed and law will be introduced. So let us try to understand the first category, that is the parliamentary history. So parliamentary history as an external aids can be understood in these three particular manner. Number one, English practice, American practice and Indian practice. So every country has their own pattern to follow or to accept the external aids to the interpretation, because one thing we have to remember is that external aids to the interpretation is the solution when words of the text or words of that statutes are not clear or they are ambiguous. But if the words are clear or words are not ambiguous or not vague, and the meaning can be taken out very easily from the text of the statute, then there is no need to follow the external aids to the interpretation, or there is no need to investigate with the help of external source of interpretation. So therefore, when you apply or when you understand or when you try to apply these external aids to the interpretation to particular statute, so here the practices which has been developed, especially in the category of parliamentary history, because as you know that when parliament introduce any law, then before introducing that law, there are certain discussions, there are certain debates, there are certain social economic conditions that they take into consideration, and with the help of that, the judiciary takes that data or takes that information to understand or to get the clarity of the text of the statutes, because even that sometimes helps to the judiciary. So first, if we see what is the English practice or how the British country has followed the practice when it comes to the parliamentary history. So how much importance was given to the parliamentary history by the British legal system? So here there are two views. First is the traditional view or traditional pattern which they have followed, and second one is the modern pattern which they are following. So in the traditional pattern or in the old days, their views or their opinion was such that the intent of the parliament, which while, or you can say while passing the act, is not to be gathered from the parliamentary history of the statutes, right? So it is very clear that initially or in the old days, the traditional English view or the traditional English practice was such that they did not give much importance to the parliamentary history. So before enacting any act or before preparing any act, if there are certain historical aspects which is covered during the parliament proceedings or during the proceedings in the parliament, so they will not have any impact, they will not have any importance. So therefore, the intent of parliament, which while passing that cannot be gathered from the parliamentary history. So that one aspect we have to remember. Then second, the language of minister of crown in proposing in the parliament of measure which eventually becomes a law or reports of the debates and to the resolution passed by either the House of Parliament are again inadmissible for the purpose of showing the intention that is the purpose of object of the act. So here what we have to remember is that even there is one more approach that was followed in the English practice in earlier days, that when the Minister of Crown, when he is making certain speech or he is submitting certain observation before enacting the act, then even that will have no value. That was the primary primary stand of the British practice when it comes to the external aids or when it comes to the parliamentary history. However, in the modern English practice, the view was changed, and they began to use the parliamentary history in the construing the statutes has been gaining ground. So they try to give the importance to the parliamentary history now, and they are giving the importance to some extent, like where the words are not clear or where the words of statutes are not giving the correct meaning. So in the case of Pepper versus Hart 1993, the Lord Wilkinson laid down that reference to parliamentary material should be permitted as an aid to the construction of legislation which is ambiguous, the literal meaning of which leads to absurdity. Even in such cases, reference in code to parliamentary material should only be permitted, and such material clearly discloses the mischief or the legislative intention, a line behind the ambiguous or obscure words. So here in this judgment, if you see, the court has very pertinently used the external aids, that is especially the parliamentary history, as an external aids, and wherein the court has not directly relied upon it, but court is relied only when there is ambiguity, that is number one, and the literal meaning of which if leads to the absurdity, then one can go for the parliamentary history. And even in case when if there is a code of the parliamentary material should only be permitted, there is such material clearly discloses the mischief or the legislative intention. So the material from the parliamentary history, or it may be the speech of the Minister of Crown, or it may be during the proceedings of the Ministry of the Parliament, the material which is directly relevant to take out the mischief, that is for what purpose that law has been introduced, what remedy that law has brought to resolve the particular issues, and the legislative intention. If these two categories are very expressly mentioned in the parliamentary history, only that particular aspect will be taken into consideration, not the other part. So therefore, modern English practice is now has changed their stand from traditional perspective to the modern perspective. So from rejecting the parliamentary history to the accepting the parliamentary history as the one of the source or one of the category of the external aids to the interpretation. Moving ahead, now we have American practice. So in the American practice, the approach of America compared to British views has been widened and the flexible. So America has a different approach. So like Britishers, if they are adhering to the initially they were not accepting the parliamentary history, but later on they are accepting the parliamentary history as a external aids. But the America has certain different view from the initial days itself, and wherein if you see the case of United States versus St. Paul M&M Railway Company, it was very well accepted that the reports of the committee, including the bill which has been introduced, changes made in the frame of the bill in the course of its passage, the statement made by the committee chairman in charge of it, and stand upon a different footing and may be resorted to under a proper qualification, right? So here there is a clear, this judgment clearly shows that the American practice which has been followed for the interpretation of statutes, and especially as an external aids, so they have taken into consideration parliamentary history in the form of reports of the committee, the bill, the changes made, and also the statement that is made by the chairman of the committee. So every aspect has given the importance just to understand the correct intention behind the legislation, to understand the correct intention behind the law which has been enacted by the parliament. Okay, so wholesale, but at the same time there is very important point which we can see further, that this rule of exclusion, like in the British practice earlier in the traditional method, there was a rule of exclusion, that they have excluded the parliamentary history and they have not given the importance, and in the modern practice they have applied the rule of inclusion, they have included the this parliamentary history as an external aids. So they have tried to have the inclusive approach. But here in American practice, there is very important observation that we have to also remember, that because initially we have seen that they have mentioned it is flexible. So flexible means what? So flexible means, you can refer this particular point, that wholesale exclusion of parliamentary history as also wholesale inclusion are both extreme equally open to the objections. So here there are chances that the American practice will also have, or American practice has a flexible approach, that if there is certain parliamentary history which is not relevant or which they are not intent to take into consideration, then they may exclude that particular parliamentary history. And but at the same time, if it is necessary to include, then also they will be open to that. So therefore, the correct solution lies in the finding out the middle course as now adopted by the House of Lords. So the House of Lords, or as a judge of the higher judiciary, what he will follow is that if the material or if the parliamentary history, either in the form of reports, either in the form of statement that is made by committee chairman of the committee, or there is the when the original bill which was introduced and the latter, the particular act which has finally came into existence, comparing both of them. So these things, whether to include or whether to exclude, if it is appropriate to include, then the court will be flexible to include those things, and if it is not appropriate to include, then court has a right to exclude also those particular things, because if it is not necessary, as if wordings of statutes are clear, then it is not necessary to go ahead with the external aids in the category of parliamentary history even in the American practice. Now let us come to the Indian practice. So in the Indian practice, now as we all know that the Indian practice which has been sustained or which has been established mostly from the British legal system. So we have adopted or we have followed certain patterns, or you can say certain most of the features from the British legal system. So similarly, even at the initial days, Indian practice was such that they also did not give the importance for the parliamentary history as one of the external source or external aids to the interpretation. So the Supreme Court of India has followed the similar traditional pattern of English courts, which is nothing but the rule of exclusion of the parliamentary history. But gradually, the court on many occasions started to take aid in resolving the questions of the construction, and now the situation is such that court considers the legislative history to certain extent to resolve the vagueness and the ambiguities. So the parliamentary history is nowadays considered as the important one, and also it has get that much importance or that much momentum to apply that particular history for the interpretation of the statute. So here therefore the approach of the court towards the inclusion and the exclusion of the parliamentary history depends upon the statutes and the ambiguity that is associated with it. So if the words are ambiguous, if the words are not clear, then obviously court will be open to apply the parliamentary history of that with respect to that particular statute. So there are, I think, several examples. Like if we take the example like Consumer Protection Act, then for the Consumer Protection Act, the history behind enacting that particular legislation, that starts from the international perspective. So like in the international level, when there was a introduction of the, or when the United Nations adopted the consumer rights as a human rights, and therefore with that, you can say with that notion, the Indian Parliament took a further step, being a party of United Nations, and enacted a particular act, that is Consumer Protection Act, in the year 1986, just after 1 year that is resolution passed by the United Nations. So the history behind that legislation is something that can be seen by the action of the Parliament, and even the judiciary can take into consideration that the consumer right has given the importance of the human rights at the international level, and similarly that can be attached to the Indian level as well. So here there is a two different views that can be see here. That is, number one, in the case of State of Travancore and Cochin versus Bombay Company Limited, AIR 1952, wherein the Chief Justice of the Supreme Court, that is Justice Patanjali Shastri, had opined that a speech made in the course of debate on bill could at best be indicative of subjective intent of the speaker, but it could not reflect the inarticulate mental process lying behind the majority vote which carried the bill, nor is it reasonable to assume that the minds of all those legislatures were in accord. So dear viewers, if you read this particular observation of Justice Patanjali Shastri, so what he has observed, he has specifically mentioned that when we are trying to take the statement from the or the speech that is made during preparation of the law, if there is a minister of a particular subject, right, and if he has introduce a particular bill in the parliament and if he has given the justification for the same. So we have to, according to this Justice Patanjali, that we have to take into consideration that whether this is the intention of that particular individual person or whether this is the intention of whole members of the parliament, right? Because there may be a difference in that, and plus it shall articulate the mental process not only of that person but the whole members of the parliament. And in addition to that, whether it is everyone has accepted the same or not, whether everyone is ready to accept that what has been proposed by the particular minister, then whether everyone has that acceptance or not. So the point here is that when we are trying to interpret a law with the help of parliamentary history or with the help of views that is put up by the member of the parliament, then we have to understand that what was the psychological aspect behind that, or what was the intention behind that, whether it is the intention of the legislature individually or whether it was the intention of the legislatures who are the members of parliament collectively, because both will give the different approaches. And therefore when the court is going to accept or court is going to try to check the parliamentary history, then that may give the different perspective. So therefore it is the opinion that is mentioned by Justice Patanjali Shastri that we have to be very careful while understanding the history of the parliament or history of that particular legislation. Now similarly, there is another opinion in the case of Indira Savni versus Union of India 1993 Supreme Court case. And in this case, the court, while interpreting Article 16(4) of the Constitution of India, referred the Dr. B.R. Ambedkar's speech in the Constitution Assembly and observed that the debates in the Constituent Assembly can be relied upon as an aid to the interpretation of the constitutional provisions that is borne out of by the series of decisions of this court. The expression backward class of citizens is not defined in the Constitution. Reference to such debates is permissible to certain, at any rate, the context, background, objective behind them, particularly where the court wants to certain the original intent, such reference may be unavoidable. So here in this particular case, as you can see that the judge in this case, that is Indira Savni versus Union of India, wherein the debates which has accepted or which has happened during the preparation of the constitution and the exchange of ideas, exchange of thoughts, expressions that has observed during the constituent assembly debate. So these facts, these circumstances, this observation assume certain importance, and therefore if words like backward class is not defined in the constitution, then one can go back and find out in the speech during the constituent assembly debate that what was mentioned, what was the reason to term it as a backward class, what was the justification for that, to what extent or to what category of people will fall under the backward class, what should be the criteria for the same. So all these answers can be found out in the constituent assembly debate. So if the court is relying upon these documents just to understand the term backward class, because it is not defined in the Constitution of India. So therefore this also creates a good example that the external aids to the interpretation, then the parliamentary history, especially like example like debate of the constituent assembly, will be helpful for the same. And moving ahead, there are again one more example, that in the case of S.P. Gupta versus President of India 1982 Supreme Court case, wherein the court observed that legislative history of a constitutional provision, though not directly germane for the purpose of construing a statute, however, may be used in exceptional cases to denote the beginning of legislative process which results in logical end, but in no case the legislative history be substitute for interpretation which is in direct contravention with the statutory provisions concerned. Okay, so external sources or this legislative history cannot substitute for the interpretation of the statutes. It can assist to the interpretation of statute, but it cannot take a major role, or it cannot take into consideration by overriding the basic principles of the interpretation of statute. And further, the statement attached to the bill describing the objects and purposes and reasons for which the bill is to be passed gives the understanding of the background, antecedent state of affairs, the object that law seeks to achieve. So hence it may help to a certain history of the enactment. So this was basically all about the Indian practice. So if you compare, or if you just try to understand the British, American and Indian practices when it comes to the parliamentary history, so every country has their different approaches, but right now in the present scenario, all these three practices are giving certain importance to the parliamentary history to some extent, and that importance is basically to the category when, or in the situation where there is ambiguity in the act, there is a unclearness or vagueness in the act. So next, let us now understand the second category, that is historical facts and surrounding circumstances. So historical facts and surrounding circumstances as an external aids to the construction of the statutes. What is the object behind having this historical facts and surrounding circumstances? This basically helps to understand that, to discover that the particular meaning of a given word in an enactment which the lawmakers intended it to be given. So therefore, in cases of older statutes, a knowledge of historical facts relating to them helps in understanding the meaning of ambiguous words and expression used in them. So according to Blackstone, the most universal effectual way of discovering the true meaning of law when the words are dubious is by considering the reason, spirit of it, and the cause which moved legislature to enact it. Because as a ordinary person, if we look at the background of any particular legislation which are enacted by the parliament, then there are some or other reasons, there are some or other social conditions, there are some or other surrounding circumstances that compel the parliament to enact law or to take certain action for the enactment of a particular legislation. So therefore, history is definitely plays an important role just to understand the existence of present act, existence of any legal document, or existence of a statute that is made by the parliament. So in case of National Seeds Corporation Limited versus M. Madhusudan, the Supreme Court has considered the background in which Consumer Protection Act 1986 was enacted, as well as the salient features to hold that the farmers, growers would fall within the definition of consumer in section 2(1) of the act, and would be entitled to claim compensatory relief for loss suffered on account of defective seeds supplied to them, and the arbitration was not the only available but rather an optional remedy. So in the Consumer Protection Act, as I mentioned, that this act is definitely the outcome of the introduction or by the adopting the certain resolution by the United Nations organization in the year 1985, which gave the consumer right as human right, and therefore in the year 1986, India being a party of United Nations, they introduced this particular legislation. But apart from that, as a consumer, when we are exercising our right, or when we know that there are certain rights which needs to be recognized, so therefore consumer right basically has been recognized by the United Nations, because prior to that even consumers were present, even the people used to consume certain products, but right as a consumer right, that nomenclature that came because of the United Nations, or the history behind the United Nations organization, that why this consumer right should be called as a human right. And further, even we can take the example of the protection of women from the domestic violence. So wherein as you can see that prior to 2005, or even this particular aspect of domestic violence is one of the menace in the society. So where the parliament or the legislature recognize this particular issue from the society, from the surrounding circumstances, that there are certain women who are facing challenges and issues, especially in the category of this domestic violence or at the domestic level. So therefore, to curb this particular violence or to protect the woman from this particular violence at the domestic level, they enacted this particular legislation. So here what court has done, or what the parliament has done, parliament has basically tried to understand the surrounding circumstances, certain facts, that how many women has faced these challenges of domestic violence, how many women has how many women has not been able to exercise their basic or fundamental rights because of the domestic violence. So therefore, the parliament, understanding the history, understanding the surrounding circumstances, they enacted this legislation, and which became the very pertinent legislation when it comes to the protection of rights of women. Then we have another category, that is social, political and economic developments and scientific invention. So this is again another category of external aids to the interpretation. So wherein according to Westman, wherein the judges are not robots, they have to evolve various methods and techniques to tackle a problem which confronts them. And especially in the era of science and technology, that is continuously growing field from in academic as well as the pragmatic point of view. So the changes which have been brought by the science and technology have laid the foundation of advancement in the legal provisions. So here the, as you can see, that if the law or the enactment like Information Technology Act or the provisions which are included in this Information Technology Act, these provisions or the enactment is basically has certain purpose that needs to be served, and the primary purpose or the primary object of this Information Technology Act is nothing but to understand that the way the information has been shared, the way information has been passed, or the way information has been misused, so that may violate the rights of the individual, that may violate the basic fundamental rights of the individual. So therefore, in this context, now this, however science and technology might have been developed, however science might have or the technology might have made the life easy of the individual, but at the same time there are certain disadvantages also, and those disadvantages, by recognizing those disadvantages, by recognizing those challenges, it is the Parliament who has taken into consideration those inventions in their mind and tried to incorporate a law in this regard. Even the, and apart from that, social, political, economic developments are definitely assist for the enactment of law. So as a judge, when they are trying to apply a particular law, because like in the Information Technology Act, there are several words like electronic signature, electronic documents, electronic evidences. So these terms are something which is new even to the you can say the people who are not included in that particular field. However, they may be enjoying that particular facility. But what do you mean by this electronic signature? How to define it? What is the reason behind adding this information or data when it, or the definition of the electronic signature or electronic documents? Which document should be called as electronic document? So the IT Act is definitely a source for that. But why this particular information is included into that? Then for that purpose, the technology also needs to be understood by the judges. And therefore, because even in the cases like cyber law cases, wherein the, when the investigation or when there is application or interpretation of this provision, then there are very technical or possible challenges that may be faced by the judges who are not maybe or who may not be very acquainted with the technology, but they know the law. There is law is in front of them, that is IT Act. But what about the investigation? What about the documents or evidences submitted before them? And how to apply that evidences, or how to apply that evidences to the facts of the case and to the existing law. So for that purpose, external aids is very important and it plays a very vital role. Further, therefore, the role of judiciary is to interpret the legal provision by considering the latest social, economic, scientific advancement in the society. And also Supreme Court has pointed out at several occasions that the penal provision should also as far as its language permits, be constituted with reference to the modern needs and not with reference to the nations of energy reduction prevailing at the time when the code was enacted. So the Supreme Court in the social, political, economic development or scientific invention, they have basically has to be one step ahead with the scientific invention, scientific development or scientific technology. So here there is this case, that is Porrett's and Spencer's Asia Limited versus State of Haryana, and in this case the Supreme Court dealt with the word textile and holding that cotton, woolen, dry felts are textiles. And it must be remembered that the concept of textile is not a static concept. It has having regard to newly developing material, methods, techniques, processes and continually expanding content, and new kinds of fabric may be invented which may legitimately, without any violence to the language, be regarded as a textile. Now here what court is trying to emphasize, in this particular case is that the term textile in the initial days, how it has been understood, and after the development in the science and technology, the word textile may include different things, because of the advancement in the technology that the textile material has been converted or has been transformed into the number of forms, so such as the new development material, methods, techniques, process and even continually expanding the contents and new kinds of fabric may be invented legitimately, and even that is a part and parcel of textile. Okay, so not only the wood, cotton or woolen dry felts. So it can be understood that law and technology has now mixed and growing together, and law should calculate the technology with development and accordingly its rules so as to achieve needs of the future society. So next aspect comes, that is reference to the other statute. Now sometimes the situation arises wherein the parliament, or sorry, the judges or the courts may not rely only on the acts which is in front of them, but there are certain situations that arises that the statute may there are certain situation arises that the statute or the court may rely upon the other statutes or may refer the other statutes which are associated with the statute which is having the unclear words or ambiguous word. So therefore the meaning of this phrase in pari materia has been explained in the American case, that is United Society versus Eagle Bank, in the following words such as: statutes are in pari materia which relate to the same person or thing or same class of persons or things. It is a phrase applicable to public statutes on general laws made at different times and in reference to the same subject. So here if you see this, what is basically highlighting is that there are, like, if the country like India, if you see, and we have a different culture, different tradition, different you can say practices, but at the same time we have certain things in common. So it may be, you can see that the way we have certain group rights, maybe environmental protection. So environmental protection is necessary at any part of the country. So when if the law is introduced for the environmental protection and considering considering as a group right, so in that group right, every state in the different region, this environmental protection is the common issue. So for the same class of person, for the same subject, law can be enacted differently, and that will have a correct value, or that will have a correct, you can say good, you can say that will have a correct value, or that will have a well validity even in the eyes of law. But what is here explained is that here this Latin phrase, that is in pari materia, is emphasizing is that if any act is enacted in this particular state and similar kind of enacted in the another state, or reference can be given to the other statutes which is present in another state on the same subject, then court may take the assistance for that. So therefore statutes which relate to the same subject, same person or a thing, or same class of person or things are deemed to be constitute one system of law, and they are considered as a one statutes. So we will take one example, then we will get much better idea. So Supreme Court has come across once the challenging the constitutional validity of the act, that is New Horizon, in the case of New Horizon Sugars Mills Limited versus government of Pondicherry, and wherein the act which was in the question, that was Pondicherry Protection of Interest of Depositors in Financial Establishments Act 2004. So in this particular act, as you can see, the purpose of this act is the protection of interest of depositors, right, in the financial establishment. So the purpose was to protect the depositor, and on the same subject, or on the same but that law was obviously applicable within the region of Pondicherry, but on the same subject there was a law which was enacted in the other state also, that is the Tamil Nadu, which is enacted the Protection of Interest of Depositors Act 1977, and the Maharashtra Protection of Interest of Depositor Act 1999. So prior to Pondicherry Act in the year 2004, so prior to that there are other two states had enacted same on the same subject, on the same class, or on the for the same kind of category of persons, some similar kind of act. So therefore to test the constitutional validity of such legislation, court may refer the other statute, right. So therefore reference to other statutes in such a manner that can be taken by the court, that if the law has been enacted in other states on the same subject, same class, same person, even that will assume certain importance. So also here one has to remember is that when two pieces of legislation are of different scopes, it cannot be said that they are the pari materia. So for example, the Bombay Rent, Hotels and Lodging House Rents Control Act 1947 and the Bombay Land Acquisition Act 1948 were held to be acts not in pari materia, as they do not relate to the same person or a thing or to same class of person or the things. So this was held in the case of Shah and Company, Bombay versus State of Maharashtra. So land acquisition and the rent, lodging, hotels, their rates, it's to control that. So this have different subject, different object. However, that may be jurisdictionally applicable in the same city, but it is not for the same class of person, it is not for the same subject. So therefore, this will not come under the principle of in pari materia. So however, it is not necessary that entire subject matter in two statutes should be identical before any provision in one may held to be in pari materia with some provisions in the other. So moving ahead, the reference to the other statutes, there are another case wherein an income tax officer was accused of taking a bribe and trial court sentenced the accused to 6 months of rigorous imprisonment. But when the appeal went to the High Court, it set him free on the basis that the accused may have simply borrowed the money instead of accepting as a bribe. So the section 4 of the Prevention of Corruption Act 1947 directs that on the proof that in the gratification other than the legal remuneration, it shall be presumed unless the quantity is established by the accused that the gratification was accepted as a bribe. The Supreme Court, while dealing with the section 4 of Prevention of Corruption Act, stated that if there is a proof that accused has accepted the gratification in any form other than legal remuneration, then it will be presumed that such gratification was accepted as a bribe unless contrary is proved. So State of Madras versus A. Vidyanath Iyer, 1958, Supreme Court has dealt with this particular issue. Now there is one important aspect that we have to remember or we have to understand here is that there was the Law Commission of India has made an attempt to, in the 183 report, that the General Clause Act is definitely an important source which can be referred to define or to get the meaning of particular words. But also they have, the Law Commission of India had been made an attempt to suggest that the codification of external aids to the interpretation of statutes. Okay, so it is very now big suggestion that is submitted by the Law Commission of India, that can we codify the external aids of the interpretation, because as you can see that we are talking about the reference to the other statutes. So General Clauses Act 1897 has definitely considered as the one of the important aspect as an external aids to the interpretation. But the codification of the external aids, that is something very challenging thing, because if you see that if the historical aspects or parliamentary history or maybe the social, political, economic development, if that is codified into the act, then that may create some different impression, because if the act, while enacting that particular act, the situation was such that act was necessary, but after some times or after like implementation, while implementation that act, this situation may not be applicable as it is. There may be some modification, there may be some changes. So codification of external aids is very difficult, and therefore, however they suggested or they gave the suggestion that or recommended that codification of external aids has to be there, but they finally it was concluded that they are unable to codify all the external aids. There may be few external aids can be codified, but not all. So therefore, this 183 report of Law Commission of India is very important in this regard, and even in addition to that, there is a 60th report, even that needs to be taken into consideration, that is submitted by the Law Commission of India, that is 60th report. Now next point comes, that is usages and practices. So usages and practices that is developed under the statute is indicative of the meaning ascribed to its words by contemporary opinion, and in case of ancient statutes, it is admissible external aids to its construction. So usages and practices, definitely it is not like only related to the tradition, culture, or the diversity that we have, but usages and practices also when it comes to a particular institution. So as a judiciary, if as an institution, what usages and practices that have been followed in that particular institution, or if we go for the administrative side, wherein what particular pattern which they have followed from number of years, so that usages and practices also assist the judiciary to interpret the particular legislation, because why this legislation is enacted in a particular fashion, that can be correlated with the usages and practices in that particular area. So the Supreme Court India refused to apply the principle of usage and practices to the Telegraph Act and the Evidence Act 1872. The doctrine is confined to the construction of language used in the very old statutes, and where the language itself had a different meaning in those days. So here when we apply the usages and practices, the one has to remember that at the time when a particular decision, if it is delivered by the court, like if it is delivered, they have delivered decision 10 years back or 20 years back, what was the situation at that time, and if the same decision has been followed for next 10 to 15 years, then whether the situation was same, in spite of having the same situation, they have enacted that law, or that they have applied that law, and whether it is similarly can be applicable in today's context. So the doctrine of this usages and practices, that too as an external aids, that depends upon the case to case basis. And further, like in the case of Motipur Zamindari Company Limited Private Limited versus State of Bihar, the question was raised that sales tax could be levied upon the sugarcane. Now the appellant argued that since the sugarcane is a green vegetable, it should be exempted from the tax, and stated that the dictionary meaning of vegetable as something which is derived from the plants. But the Supreme Court rejected this contention and held that under common usage, a vegetable is something that is grown in kitchen garden and is used to consume during lunch or dinner, and it further held that sugarcane was not a vegetable and was thus liable to the sales tax. So basically here when we talk about such you can say vegetables or like certain fruits or foods, so we have to understand every category, how it is basically inserted in the law, what is the intention behind the inserting such category into any particular law or legislation. So the sugar cane, you can see, as the cannot be considered as a vegetable, because the process of, you can say, process of sugar cane compared to the other vegetables is very different. The use of sugar cane compared to other vegetables is very different. The usage and practices, however, that may be eating in both the categories, one can use to eat the sugar cane, but the process of its manufacturing, process of its use, process of its daily routine is different from the term vegetables, which is expected under the Sale Tax Act. So therefore sugarcane is not vegetable, it is liable to pay the sales tax. Now there is a time come when there is a Latin phrase that we have to understand, is the contemporanea expositio, which means that the best meaning of law or document is the one given by the people who made it or signed it. So even a long standing practice sanctioned by the judicial decision can be recognized here, and the legislation may be overruled if there was no legal basis for it, and if in the changed circumstances its continuous led to a great hardship. So in the year 1969 overruled. Okay, now let us come to the next point, that is use of foreign decisions or documents. Now when we talk about foreign decisions or the documents, then as a common law system which we have followed, in the common law system wherein the judgment laws has given certain importance, and especially like country like India, wherein we have adopted or followed certain British features of legal system, then in this process the reference to the decisions of the English courts was a common practice in the administration of justice in the pre-independence India, and the assistance of such decisions is subject to the qualification that prime importance is always to be given to the language of reliable Indian statute and the setting in which it is enacted and the Indian condition where it is to be applied, and that it is not to be forgotten that there is always an element of risk in taking ready at assistance of such decision. Now what we have to understand here is that when we talk about foreign decisions, then as a judge he has a definitely helping hand of these foreign decisions, he can take the assistance of these foreign decisions, but one judge has to be very careful when he is going to apply that foreign decisions into the particular facts and circumstances at the Indian context. So one may not apply that foreign decision as it is to the Indian context. So for that matter, judge may have to apply the mind in such a way that what are the facts of the particular case and what are the ratio of the foreign decisions which can be applied to the relevant facts of the case. So therefore, as it is mentioned here is that there is always the element of risk that the assistance to this such decision is very, no, one has to be very careful. So one cannot directly apply the foreign decision as it is. So for that matter, even the subject like certain tortious actions, or when the matter is come to the tortious action, there are several principles that has been laid down through the foreign decision. So it may be case like Dunnock versus Stevenson, which has come out with the principle of negligence, or it may be a case like Reliance versus Fletcher, which has come out with the rule of strict liability. So these like landmark cases are like foreign decisions that is declared by the foreign country, but India has adopted that principle in our judicial system or while deciding the case or deciding the judgment, and those principles had assumed the importance that this has become the law that is declared by the court. So under the common law system, we definitely give the importance to the judgment of higher judiciary, but especially in the case of tortious action, wherein there is no enactment as such that has been introduced by the parliament yet, because law of torts is basically depends on the civil wrongs, and the civil wrongs can be of number of types, and it is very difficult to prepare one single legislation in that regard. So therefore, the foreign decisions or the decision that is delivered by the foreign judge, that sometimes assist for the judges, but however it is not the mandatory that we have to rely on the foreign decisions all the time. Why? Because in the foreign decisions, like there is a case like MC Mehta versus Union of India, wherein the Justice Bhagwati has rejected to apply the foreign decision or their principle, and Justice Bhagwati has come out with the new principle, that is absolute liability. So therefore, the principle of absolute liability has override or has taken the different perspective when it comes to the application in case of the hazardous industry, or in the case of the industry which are hazardous in nature. So therefore, foreign decision, yes, they do assume certain importance, but it is not mandatory that to apply those foreign decisions as it is. Then there is as it is mentioned, the foreign documents. So international law and human rights document. Now this international law and human rights documents also considered as the one of the important source of external aids to the interpretation. And under this international law and human rights documents, the United Nations organization, that is the prime, or you can say the organization which is at international level, they have declared certain basic documents such as Universal Declaration of Human Rights, or the International Covenant on Civil Political Rights, or International Covenant on Social, Economic, Cultural Rights. So such documents, and also they have introduced certain convention. So India being a party of this covenants or the convention, it becomes mandatory to India, as they have ratified this some of the convention or in the covenants. So it becomes mandatory for India to incorporate that into the law which is enacted by the parliament, and plus even the judiciary has to, or judiciary may take the assistance from this foreign legal documents, like in the case of Vishaka versus State of Rajasthan, wherein in the absence of law, the judiciary, that is Justice Sujata Manohar in that particular case, took the assistance from the international law documents, because there was no law present at the national level or at the domestic level to protect the woman from the sexual harassment at the workplace. So judges have applied or has taken the assistance from the foreign documents, that is the CEDAW convention, and with the help of CEDAW convention, the judiciary interpreted the law in such a manner that they prepared certain guidelines for the protection of women from the sexual harassment at the workplace. So international law and human rights documents assume really a great importance, and the human rights ultimately is such a term that is universally applicable, and the documents which are associated with that, that is applicable at the universal level in the equal footing. So when there is a guidance is available from Indian decisions, to then reference to the foreign decision may become unnecessary. So already if the Indian decisions are well versed with the already if the decision has given the good explanation, then there is no need to go for the foreign decision. Like as I mentioned, in the case of there is a wrong that is committed by the certain chemical industry, hazardous industry. So here one need not go for the rule of strict liability. One can directly apply the Indian jurisprudence which is developed by Justice Bhagwati through the case of MC Mehta versus Union of India, that is nothing but the absolute liability principle. So however, the courts have referred to the American decisions, especially when the matter is connected with the fundamental rights, and these judgments have a persuasive value and there is no law on point. So it has a persuasive value, it can be considered as a guiding principle, but it cannot become a mandatory that one has to follow that decision as it is. So even in the case like administrative law or administrative decisions, there are a number of principles like Venesbury principle which talks about the reasonableness. So this reasonability, that Venesbury principle can be considered as the guiding principle, but it cannot be mandatory for the court or Indian judiciary to adopt it as it is. Okay. The next comes dictionary and textbooks. So dictionaries are something that gives the clear meaning to the words, and as a common man we definitely use the words. When we don't understand the word or meaning of word, then we refer the dictionary. In similar manner, even the judiciary can take the assistance of dictionary, and there are certain dictionaries which are landmark dictionaries such as the Black's Law Dictionary or Oxford Dictionary, which can be considered as the authenticated source to understand the words or legal words, and therefore one may use for the same. So the context in which the word is used can be understood, but it may not be necessary that the court can rely upon the dictionary 100%, because there are certain definitions that are already given in the act, explanation is already given in the act, even one can use that aspects also. So as observed by Justice Krishna Iyer here, that dictionary are not dictators of the statutory consideration, where the mode of law and moral ethical, the definition clause is furnished by the different denotation. So in the conclusion, I would like to state that what we have covered in this particular lecture is that the importance of external aids to the interpretation, the difference between internal aid and external aids, how they are different from each other, the different types of external aids which is inclusive of parliamentary history or maybe historical facts, surrounding circumstances, social, political, economic development, scientific inventions, reference to other statutes, usages and practices, dictionary and textbook, and use of foreign decisions and the documents. So this is basically a brief outline or overview of the external aids to the interpretation. So with this I conclude my lecture. Thank you.
Hello and welcome to this piece of literary snippet. We usually know William Shakespeare as the most revered figure in the history of English literature. But we often tend to forget that he has also been one of the most hated figures in literature. And here I'm not talking only about those boys and girls who have to memorize long sections from Macbeth or King Lear or Julius Caesar before they can go and sit for their school or college exams. But I'm also talking about people who are themselves quite famous authors. Tolstoy, for instance, considered the writings of Shakespeare to be, and I quote, crude, immoral, vulgar, and senseless. George Bernard Shaw absolutely loathed Shakespeare, as he did Homer. But perhaps no other criticism about Shakespeare is more damaging than the one which says that Shakespeare is a marvelous storyteller, provided someone has told him the story earlier. Now, this piece of criticism is particularly damaging because it is true. None of Shakespeare's plays contain any original story whatsoever. They are all written using pre-existing materials, pre-existing stories. Now, does that diminish the stature of Shakespeare as a dramatist? Well, I'll leave that for you to decide. See you in the next episode of Literary Snippets.